Okay. Next case is TRAPUZZANO versus State. Morning.
Good morning. My name is Susan Fagan, and I represent Mr. TRAPUZZANO in this appeal. There are 5 issues raised in this appeal. 3 concern what happened in the trial, and 1 in sentencing, and the main point is whether or not the state proved its case against Mr. TRAPUZZANO of possession of cocaine. In essence, the state proceeded on a potato chip theory. As the Byers case, which I filed as supplemental authority, points out, critical evidence in a constructive possession case is dominion and control over the alleged contraband. Trial court summed it up. Somebody put the chain on the door, wasn't the defendant. What do you think happened in between the time Mr. TRAPUZZANO left the room and the chain was put on the door? From the inside, which had to be bolt-cutted by authorities to get back into the motel room. The proof that the state relied on simply didn't pass muster as a matter of law. We have...
Can dominion and control be proved circumstantially like almost anything else?
Dominion and control has to be interwoven with actual knowledge and ability to...
Of course, actual knowledge is something that's almost always going to be...
Correct.
Subject to circumstantial evidence unless a guy comes out and says, it's mine, or it's on his person. So I guess my question is, if it seems to me that dominion, control, and knowledge are all issues that are subject to being proved by circumstantial evidence, and if that's correct, is it then our function to look at all of the evidence here and say, does this demonstrate knowledge, control, and dominion, or does it not? Is there a reasonable hypothesis of innocence that is inconsistent with... Now, I assume your hypothesis of innocence is that, yes, they were doing drugs all night, but not these drugs. And yes, they were doing them in this room, but not these drugs. And he left the room to go do something, and he comes back and...
For an indeterminate period of time, correct.
Well, I thought there was some testimony that he just went out to his car to get something, and shortly thereafter called the police, or called the manager, or did something. The police show up. But I agree that the record doesn't say 10 minutes or 5 minutes or 30. It just says something like a short time later.
Mm-hmm. Well, that's, Judge Orfinger, that's the crux of our case, is our appeal, is that their reasonable hypothesis of innocence has not been sufficiently rebutted by the state's evidence, even when viewed in the
So your theory is essentially that it's a reasonable hypothesis that whatever drugs he was aware of, that they consumed them all. He leaves the room, she whips out her own stash, and then he comes back, and lo and behold, there they are. That in your mind is a reasonable hypothesis of innocence versus this was just part of the stash of drugs that they were doing together.
Absolutely. There is no proof of that particular contraband found by her nightstand after all the rigmarole of getting back into the motel room. And again, as you mentioned, with no real, we're not having Mr. TRAPUZZANO coming, immediately out of the hotel room as authorities come up, or et cetera, et cetera. There is certainly no statement by the defendant as to those drugs. And therefore, under the law, and look at the Byers case, filed a supplemental authority, and the general case law, the state has not proven its case and not sufficiently rebutted that hypothesis, that reasonable hypothesis.
There was no statement by the woman in the room as to the drugs either? Nobody said anything about claiming ownership or
no
anything about that?
No.
Okay.
No. And
she pled, correct? I mean, she pled
that's
out.
correct. Which ties into the sentencing issue, which will, if we can't get to all points I would like to reserve 5 minutes for rebuttal, by the way. But I think also when you look at the egregiousness of the prosecutor's comment on, or directly asking Sergeant Curtis, whether or not the defendant made any statements of that's not mine, that's not my crack, that's not my cocaine. That when you have the central core issue being possession of cocaine, that there's just no reasonable way to look at this as was touched on in the previous argument, harmless error. The jury was there to decide who possessed those drugs. And when you tie that into Sergeant Curtis's improper testimony as far as the mistrial about admitted using drugs, we don't know what drugs, when, where, what. It just snowballed into an avalanche of prejudice against my client when the jury had to make its final decision of whether or not.
Are you referring to the statement when Mr. Trapuzzano, the police show up and one of the officers says to him, well, what's going on here? And he says, well, we were doing drugs all night, and then I went to the door, or went to the car, and I came back and it was locked. Is that the statement that you're talking about?
Well, the issue was both issues. One touched on when Sergeant Curtis was talking about the Miranda, giving Miranda to Mr. Trapuzzano, the Miranda warnings. And he said because Mr. Trapuzzano admitted he used drugs, all right, that's the one statement. But the other statement is the question directly asked by the prosecutor. Did Mr. Trapuzzano make any statements of denial to you? That's not my crack. Those are not my drugs. And the trial court overruled that objection. And the Sergeant Curtis was allowed to answer.
So
no.
you're claiming that's an impermissible comment on his right to remain silent?
Absolutely.
And Sergeant Curtis said what? He said
No.
no.
Right. Absolutely. And so when
You say, I don't recall. I can't.
Words to that. But
He said, I don't recall. You know what he said?
My recollection of the record is, I believe he said, not that I recall. Not that I recall.
That was it.
Right.
He didn't just say flat no. He just said not that I recall.
Right, but still, when you look at the flow of the trial, and you look at all of this, the previous error about, I didn't want to ask him. I was waiting for Deputy Rawls to show up, and he'd already admitted drugs, and then you tie in this, asked by the prosecutor of Sergeant Curtis. And when your central issue is whether or not Mr. Trapuzzano possessed the cocaine, you've got a disaster waiting for you as far as fairness. It's just eroded. But of course, our main contention is that the proof itself falls and cannot stand under the law the reasonable hypothesis of Mr. Trapuzzano's innocence. And again, the sentencing issue has the trial court acknowledging what the plea was with the co-defendant and Mr. Trapuzzano, the plea offer. And the problem is the state is saying that you have to establish that the trial court under Wilson and Evans' case got in there and started suggesting the plea or interjecting itself. And we're maintaining that, no, you have to look at the totality of the circumstances, the disparity of the sentences, meaning the sentence offered at plea and the sentence actually imposed. And when you look at the facts cited by the trial court, they just don't add into any type of an aggravated factor for the higher sentence of 270 days versus time served. And I'd like to reserve the remainder of my time.
Okay, you've got about 4.5 minutes left.
May it please the Court, Anthony Golden with the Attorney General's Office representing the state. I'll start with the first point, the sufficiency of the evidence point about dominion and control. I first note that this is not a purely circumstantial evidence case. The reasonable hypothesis of innocence cases refer to cases based solely on circumstantial evidence.
Well, what evidence do you have that he was in dominion and control of those drugs when he was locked out of the room? And the drugs were found next to the co-defendant that was passed out on the bed.
It was his room, and he said he left to go to the car, and the door locked behind him, or she locked it behind him. So his later statements that were admitted into evidence were that we'd been smoking crack all night. So there was no one brought drugs into the room.
So your evidence is that he was the one that rented the room, and that he said that he was smoking crack all night, and that's your evidence that he was in dominion and control over these particular drugs when he and the police re-entered the room?
I say that it's a jury dominion. That Byers case that was cited as supplemental authority says this is the type of issue that is a jury issue. That dominion and control, knowledge, all those things are matters properly submitted. The notion that somehow these drugs magically appeared in the room when he admitted that they'd been smoking crack all night, he didn't say we'd stopped smoking. He said, I went to the car to get something. So there was no drugs brought in the interim, and apparently...
Well, it's not really what he didn't say. It's the evidence that the state produced to show that he was in actual constructive possession of these drugs. Isn't that essentially it?
You said it's not a wholly circumstantial. Right. What direct evidence do you have that links him to these drugs?
Well, I can't say that each piece of crack that we have proof of. They just said, he said they had been smoking crack all night.
Well, why is it unreasonable to think, and I agree that there are a multiplicity of reasonable explanations here, but if the two of them are in there smoking crack and they consume their supply, he goes out to the car to get something, she has concealed her own little stash that she doesn't want to share, and while he's gone, she's going to have her own little party. I mean, under that scenario, which isn't far-fetched.
It's possible.
I mean, he didn't even know it existed. Probably if he had, he would have joined in the party, but
we don't know
he didn't even know it existed.
The evidence is that he came back to the hotel room from the car, beat on the window, couldn't awaken her. The hotel manager came. They couldn't get into the room. By this time, the first police officer arrives. He looks in and sees her passed out in the bed. She wasn't using any crack cocaine. It was...
Well, the fact that she locked the door from the inside and put the chain on it even supports what Judge Warfinger's saying, that she had her own stash and she didn't want to share.
Or she passed out. I think it's a good question for the jury. I think there's a hypothesis here, but this man never denied anything.
Why does he have to
Anything. He was very forthcoming.
Why does he have to deny anything?
doesn't
It's the
deny.
state's burden to prove the elements of the charge. He doesn't have to deny anything.
What I'm saying is he was totally cooperative throughout what happened. The police officers both said that. He said, "We've been smoking all night. I went to the car. I got locked up."
You've told us that the only direct evidence that you have is that he rented the room, it was in his name, and that there was a statement by him that they'd been smoking crack all night, and that's it, right?
Yes. It is arguable she could have hidden it, but that's why I have a jury.
And you think that's sufficient to sustain a conviction based on actual or constructive possession?
I think they went to the hotel room together. They brought their cocaine there. They smoked it. He went to the car and got locked out. She didn't leave and go buy any. You could argue, which obviously they did, that this was her secret stash. But she wasn't smoking. She was passed out on the bed. She already had to.
But she had to get up to lock the door.
Yeah.
So we know that she could not have been incapacitated the entire period of time.
Right. She locked the door and apparently passed out in the bed.
She locked the door to keep him from sharing.
What was left of their stash.
How do you distinguish?
I understand the issue.
How do you distinguish this case from the trying to read the name here? The Byers case.
Yeah, Byers just says that this is a dominion and control is best left for the jury, and this is why you have a jury. This type of issue.
Can you distinguish it by saying that the jury decided, right?
Yes, I think this is the perfect situation for to present this type of issue to the jury to see if assuming it's a reasonable hypothesis or not.
Is there a length of time where we cut it off and say, for example, I mean, he'd been locked out of the hotel room for an entire day and finally got in. Is there a length of time where we say, he doesn't have dominion and control anymore, because we don't know what the time limit was in this case?
Well, I don't know that. They said it was a short time. He said it had been smoking all morning. He went to the car and couldn't get back in. So everyone seems to agree it was a short period of time, whether it's 5 minutes or 20 minutes, we don't know. But I think the answer to your question, whether it's 12 hours or 20 minutes, is not crucial. The question is, how did those drugs get in the room, since it was his room, and who brought them there? And I think that's for the jury to decide, especially given the admissions that they've been participating in this all night.
He didn't go to the car to get some more crack, did he? We don't know that.
Well, apparently they didn't search the car. So.
They were out.
Mr. Golden, you said that you distinguish Byers by saying that the holding of Byers was that the jury should decide these sort of questions, essentially. Is that right?
Yes,
Of course, I guess my comment would be twofold. Number one, Byers reversed the conviction, so apparently they didn't leave it to the judgment of the jury, but the whole statement is whether an individual has dominion and control is generally a fact of issue for the jury. However, a judgment of acquittal is proper when the state does not adduce evidence from which dominion and control can be inferred. So I guess the question that I would pose to you is, what is the best evidence that you have that would allow us to infer that the defendant had the knowledge that the drugs were there and the ability to control them?
well, the best evidence is his admissions and the fact that it was his room and that he said he brought this woman to his room and that they'd been doing this all night.
And is that a more reasonable inference, to infer that he knew of these drugs? Is it more reasonable than we smoked what we had and I just went out to the car to get something and she pulled out her own stash? I mean, is one of those more reasonable than the other? Or are they both equally
Yeah,
plausible?
this was just, it was a fluke that he locked himself out of the room.
No, he didn't lock himself out of the room. She locked him out of the
He
room.
he said he didn't bring his key.
Well, even if he'd had his key, even if he'd had his key, he couldn't get in. The room was chained.
Yeah, and she
So-
passed out. Yes, I understand what you're saying. She locked him out of the room. Apparently, he did not pick the best of friends.
My point is that if both of those scenarios are equally plausible, or even if they're not equally plausible, if they're both plausible, they both pass the straight face test. You know, can a conviction stand on that evidence?
Well, I would say they're not equally plausible, but I say the conviction can stand based on what we have, that she was not participating in any drug taking during the time he went to the car and the time the police showed up. It was just, it's whether you can divide pieces of crack cocaine that they've been ingesting all night and say, he didn't know about this piece, he did know about that. I think they were doing just what they said they were doing. They were sharing crack. That's all I have to say about that issue. If there's some other issue that you wanted me to address, I'll be happy to. There's 5 issues.
Well, the only other issue that I took a little interest in, but I didn't think that it was overly important consideration of the other issues, was the waiver issue of the Miranda warnings. It appears that they were arguing that there may not have been a waiver, and the trial judge at one point said that I don't think there was a waiver, but when they took him outside, he really wasn't in custody, and therefore, the Miranda didn't really apply.
Well, there was only 2 witnesses.
Where is the waiver of the Miranda warnings? Where is that established in the record anywhere?
Yes. Page 103 or 104, Sergeant Curtis defendant said he understood his rights, wished to speak, had a clear, sound mind, and waived Miranda.
Why would the trial judge say that he didn't find there was a waiver?
Because up till the 3rd time they recalled Curtis.
That's when they recalled him the 3rd time to get the waiver in. Okay.
Right.
I got you.
108, the judge ruled.
Right.
Miranda was read, understood, and waived.
Okay. All right. Very good.
Thank you. We'd ask
Thank you.
the court affirm.
Got 4.5 minutes left.
4.5? Judge Orfinger stole my thunder from the Byers case, where the quotation is, where only proof of guilt is circumstantial, no matter how strongly the evidence may suggest guilt, a conviction cannot be sustained unless evidence is inconsistent with any reasonable.
Yeah, I think it's pretty clear that opposing counsel really didn't distinguish the case very well. I mean, but we'll deal with it when we get back in the conference, I guess.
And as far as the Miranda issue, Judge Sawyer, that you took interest in, our argument is they can't bootstrap the Miranda given by Sergeant Curtis.
Why not? If Miranda, are you saying that every time a different officer questions an individual after Miranda had been given by, previously been given by an officer, that officer has to re-give the Miranda warnings?
Under these factual circumstances, our argument is yes.
What case law do you have that even supports that proposition? Say, for example, a police officer properly gives the Miranda warnings and the defendant waives the Miranda warnings. Another police officer comes along, takes the defendant outside and questions him without re-giving the Miranda warnings. What case law do you have that says that any statement that defendant made to the second officer is suppressible?
Well, the case law in the brief talks about, I believe it was the James case. There has to be a waiver must be a free choice, no deception.
Right, let's assume that there's no doubt that when the first officer gave the Miranda warnings, there was a proper waiver. Another officer comes along and questions the defendant without re-giving the Miranda warnings. Are you saying that anything that the defendant says in the subsequent interrogation by the second police officer is suppressible because the second police officer didn't re-give the Miranda warnings?
That's under these circumstances where the second cop shows up, the police officer shows up in a indeterminate time. I mean, we're not saying that it wasn't at some point in time that he was summoned to the scene, but this situation.
I'm not aware of any case that would say even if he showed up the next day. Don't get greedy now, Ms. Fagan.
Well,
You're pushing the envelope on that one.
Isn't it really the case that once you give the Miranda warnings and the defendant waives, that another police officer can come along and question without having to re-give the Miranda warnings, and the court can accept those statements as freely and voluntarily given? That's the state of the law, isn't it?
If there is a sufficient,
Okay.
yes,
Enough of
Your
that.
Honor. If there's a sufficient factual circumstance of a flow of Miranda warnings and the continuing interrogation.
Did you have any other
Yes.
issues you wanted to cover before you? Is that it? You finished?
I think we'll
Okay.
stand
Thank
on
you
that.
very much.
Thank you very much.
Thank you both.
Are the parties